Good morning and good afternoon to everyone. Welcome to by Eltoma Corporate Services today and myself. To begin with, I just want to make a few notes that you can leave your messages today in the chat box. We would have some time, hopefully, at the end of today to review some of the questions that you may have. If we don't have time today during or after the presentation, I would or my colleagues would come back to you with some clarifications thereafter. So let's begin. Sorry for this delay, there were some technical issues. Right, so today's subject is UK jurisdiction. We're going to talk about UK business insight, and we'll cover a few subjects about most common organizational structures and their maintenance. My name is Dina. If you're not yet familiar with myself, I'll give a quick introduction. I have joined Eltoma Corporate Services early in 2011 when I've relocated to Cyprus after being working in Moscow, and I've graduated there as well for economical studies, financial advice, and international business development. So currently I'm holding the position of corporate services manager and business development in the company. So if you have any questions potentially with any structure in any jurisdiction, or just generally want to get more information about what we're doing at Eltoma, how you can become our partner or our client, please welcome. I would be gladly discussing those questions with you. Our agenda for today consists of two major parts. Part one is basically covering three key types of most common company organizational structures in the UK. We're going to talk about limited liability company, and we will consider the differences and maintenance of limited liability partnership and limited partnership. And at the end of our presentation today, we'll quickly have a look at the short snapshot of taxes for those structures, and we'll discuss some common implementations of those structures in the UK. So let's begin. To begin understanding of legal structures in the UK, helpful to understand what are the differences. So here on the slide, I give you an examples of two major categories of their businesses, of organizations. So you can have unincorporated business organization, or you can have incorporated businesses. The term unincorporated organization describes any organization which is not a legal person, which is separate and distinct in law from its members. It is basically an organization which is not a corporate entity. Business can run purely to make profits, and usually, obviously, that would be a sole trader or a partnership, general partnership or limited partnership. During our presentation today, we will review most attractive partnership types, but before we begin, it's important to know that usually in law, partnerships are not legal persons or entities distinct from partners. And limited partnerships are unincorporated firms, and we'll talk about them later on today, usually. However, these limited partnerships should not be confused with limited liability partnerships, which are incorporated entities, and they would be considered also today during our presentation. Registered company is the most popular legal structure for business organization, not in UK, but pretty much anywhere in the world. Types of companies that can be registered in the UK are displayed here on this slide, you can see. And the registered company is believed to have become popular since 1862 because it has offered businesses some key attractive characteristics. There are 5 major criteria which attracts business to incorporate a company. These characteristics are separate legal personality, it's limited liability, option to transfer your shares, asset shielding as well, and lastly, it's a legal framework designed to preempt and provide remedies for problems arising out of their separation of powers, ownership by shareholders and their directors. So you can see on the slide there are four major types of incorporated businesses. Companies limited by shares, which have their own subcategorization. There are companies limited by guarantee, and there are some other most commonly used types for specific occasions, let's say companies and community interest companies. We will discuss today in detail the most common company type, which is company limited by shares mostly. Before we begin going into details regarding company limited by shares, just a quick hint for you. If you are considering to incorporate one of those structures that we will be covering today, you can find useful these legislative acts that would govern maintenance, registration of those organizational types. For company limited by shares, it would be Companies Act 2006. For limited partnerships, it's Limited Partnership Act 1907. And for limited liability partnerships, LLPs, it's Limited Liability Partnership Act 2000, which is, and you will see it later, pretty much copying most of the positions from Companies Act, very similar. Obviously, there are much more various regulations and acts which would help you to assist, such as annual returns, accounts, directors' reports, etc. So they are separate regulations usually, and they're not very hard. Right. To begin an understanding of benefits linked to limited companies, let's review key differences between registered companies types and in general, what is the difference between companies limited by guarantee. So private company limited by guarantee is the company that doesn't have a share capital and its members are guarantors rather than shareholders, limited to the amount they agree to contribute to the company's assets if it's going under winding up procedures. Usually it's used for non-for-profit charity organizations, hence we will not be covering this particular type today. Private company limited by shares. Company has a share capital and the liability of each member is limited to the amount, if any, of course, unpaid on their shares. However, the key difference between private and public company, the private company cannot offer its shares for sale to the general public, whereas public company obviously may have an option to be quoted on the stock exchange. So what are the advantages of private limited company? It's limited liability, potential tax advantages, simplicity in running a private limited company, personal assets separation, so-called asset shielding, and minimum capital requirements. All of these make this type of company most common form of registered business in the UK. Now let's move on and talk about registration briefly and generally how to maintain the company, which is a private limited company by shares. To incorporate the company, you should first obviously choose the place of location. It could be England, Wales, Scotland, and Northern Ireland. Obviously, usually from my experience, if you register for international business and you're located abroad, your first choice would be England. However, if you're thinking about partnership and especially limited partnership, that would be Scotland, and we would cover the point why it would be Scotland when we would be talking about that particular type of organization today. Application for registration is pretty much straightforward due to the fact that filing is electronic, which makes the process pretty standard and simple, which is great. And UK in general is attempting and bringing such measures in place that would bring international business to the UK fluency and simplicity. And I think it's doing pretty well with this regard. You can adopt model articles, and that is the easiest and most common way. Of course, there may be some amendments and model articles, or other articles that you may adjust, should be approved, submitted to the registrar during their application. Name reservation is usually not available, but obviously we can check the availability of the name in advance to make sure that there is no duplication. Set of documents that you would be receiving consists of 4 major things, I would say. All you receive from the registrar of companies is actually a certificate of incorporation that confirms the fact that the company was registered. Then you have memorandum and articles of association. As we've discussed, you can adopt the model one, or you can adjust with our service provider if just some specific things that you should include. Minutes of the first meeting of directors and share certificates of the company, maybe also a stamp for the company. But those 3 last positions that you see on the slide are usually prepared by their service provider, or yourself if you want to engage yourself, obviously. Right, this slide here shows you the difference in the structuring of the company between private companies limited by shares and public companies limited by shares. So as we have discussed, private companies are known to be simplified for the running to make the costs lower, and hence the minimum requirement for the private companies is to have at least 1 director. And it used to be that at least 1 director should be individual. However, with the implementation of Small Businesses, Enterprise and Employment Act from 2015, which was adopted in October 2016, there is a prohibition on corporate directors. At the same time, however, private company does not need to have a secretary unless, of course, you specifically want to include this provision in your article and require this to be in place for your business. When we compare public companies to private, then we see that in public companies, the requirement is already at least 2 directors, and secretary would be an obligatory requirement. We'll talk about the role of the secretary just in a second before we sorry, it's here on the slide, yes. So as we understood, the private company do not have to appoint secretary unless their articles provide this, but company which is public, they should have at least 1 secretary. Interestingly, legislation does not set out the role of the company secretary as it is. Obviously, there are different regulations, and there is corporate governance, code of conduct, which would specify and focus a lot on the role of the company secretary. But generally speaking, each company would make a decision what to include in the contract for their secretary. And usually, secretary should undertake the following responsibilities: for maintaining all statutory registers, ensuring that the company files statutory information in time, promptly, and in line with the current legislation, and also providing members and directors with meeting notices, and also assisting to prepare various resolutions that have been discussed during the meeting, etc. There may be other obviously functions that could be implied for the company secretary, but as I said, that depends heavily on the type of business and the company itself. When you're choosing the name of the company, You should remember, obviously, about some restrictions in place. For limited company, private, there at the end you will see limited or LTD. For public company, it will be PLC, which is clearly give you the distinction between these two types. On the slide, you see some key restrictions for when choosing the name. Obviously, there are some sensitive words that can't be included, connections with government, etc. Also, you should remember that you cannot choose a name which is already registered or similar to what is already existing, basically. And there is a terminology used in guidelines, names same as or too like to existing name index, which can't be used. If you're working with Eltoma Corporate Services, of course, we'll discuss the name prior registration, prior submitting an application, and we will identify what you can or you cannot use for your business. What else you need to know is that every company needs to have a registered office. The registered office must be a physical location where notices, letters, and reminders can be delivered to the company. The registered office does not need to be the place where the company carries its daily businesses, but it has to be officially noted on the registrar where company prefers to keep certain documentation. Here on the slide, you can see the requirements that the company should maintain under chosen location. There are various registers, information about the mortgages, registers of interest, shares, etc. If you do not want to use for that reason registered address, then you can choose sale address, which is single alternative inspection location, and that address should be again disclosed on the company house website. I would like to move on now and talk about company management in general and what are the differences between directors and shareholders, who can do what and what responsibility each position carries. Let's talk about directors first. The legal duties of directors are an essential part of the legal corporate governance framework. For the ease of reference, directors' duties may be divided into two major parts: corporate governance duties and conflict of interest duties. Corporate governance duties, it's an approach of the law where it is required for directors to arrive at decisions by a satisfactory process. We have, by the way, a special separate webinar covering corporate governance where we will talk more about these responsibilities. But basically, what it says that corporate governance duties, it's compliance with required statutory guidelines. Conflict of interest duties, it means that the primary role is to discourage individuals empowered to manage companies from acting in their own self-interest or in the interest of person other than the company. So there shouldn't be the mix between self-interest and the company interest. Company interest comes first. And obviously, there are major administrative duties which are imposed on directors, and I would like you to make sure that you take a note of this. The director is responsible for making sure that annual returns, now called confirmation statements, are submitted, that annual accounts and tax returns are prepared and filed to HMRC and Company House, that all changes in the company, including allotment of shares, registration of charges, company registered address, or any structural changes should be properly recorded and submitted to the company house. This is the duty of the director to make sure that it happens in accordance with the law, regardless whether or not there is another person in place, like a professional secretary or professional service provider, being auditor, accountant, assistant with those duties. It's still lays within the responsibility of the director to make sure that all is happening appropriately. Talking about shareholders, let's just focus for a second on the types of shares. Here on this slide, you can see that there are different types of shares. There could be ordinary, redeemable, cumulative, preference shares, and each company is free to choose what share structure they want, what types they want. They can mix and match, and obviously this planning comes for the bigger group of shareholders, where you actually need to reward some of them and negotiate, buying powers and investment from those shareholders. What about the duties of shareholders? They are very different from their responsibilities and duties of the directors, actually. The law requires certain fundamental decisions and only fundamental decisions to be made by shareholders. The Articles of Association usually reserve a right for shareholders to sort of direct the board of directors by a special ordinary resolution on a specific matters. If the board of directors is for some reason unable to act, then the power will revert to the shareholders and only then. And obviously shareholders should reserve the right to remove directors from the office, but clearly there are certain procedures in place that should be followed in accordance with the Companies Act. So the main key summary of what we've just seen here on the previous slides is that directors, they have daily responsibility of managing the company. They have a control over the actions of the company, but with that control and powers comes high responsibility. They would be liable for all what company is doing, and there are criminal prosecutions if the company is in breach of certain things. Whereas the shareholders, they are residual controllers, and they are not responsible for certain actions, and their responsibility, let's say, is pretty much limited just by their contribution in the share capital of the company. So the risk is limited. Let's move on to the part where we will talk about maintenance requirements for the companies. So the first thing that I would like to mention that on an annual basis, there is a confirmation statement that should be submitted to the Company House. From June 2016, UK limited companies and limited liability partnerships are now required to file an annual confirmation statement instead of the annual return. This change also has been introduced by the Small Business Enterprise and Employment Act, which we've seen before and discussed about the requirement for having only individual directors. And the purpose of the confirmation statement actually is exactly the same as the annual return. What you need to know that you must file at least once every 12 months this confirmation statement. The key difference and why it was implemented, because the confirmation statement is a simplified process, and as I said, UK is brilliant for that. They're always trying to make life easier for their business entrepreneurs, service providers, and they actually implement and changes. There is like a 14-day rule that you need to remember, meaning that every year you should file to Company House the confirmation statement within 14 days of the anniversary of your previous confirmation date, which is usually called the made-up date. If annual return confirmation statement, is not submitted, the registrar might assume that the company is no longer carrying on business. Basically, it's not legally compliant with the basic status requirements, and there could be unpleasant actions towards the company, resulting in the company potentially being struck off the register. Following on, Talking about confirmation statement, I would like to give you understanding what is actually included or what kind of information is confirmed on an annual basis. The company should confirm its name, registered number, obviously the date when this is being filed, principal business activities, which is very important now, and you can't proceed without choosing the classification of your business activities, the special codes provided by the law. The type of companies, registered address or sale address, which we've discussed, details of the secretaries, directors, shareholders, and share capital. And lastly, the details of persons with significant control. I've highlighted this in red just because this is also quite a new requirement still, and I personally come across that not everyone still understands that this information has to be provided, and this is live, this is ongoing change. And I will now talk you through what is actually the register with for persons with significant control. So on the 21st of December 2015, the government published statutory and non-statutory guidance on the people with significant control register and the meaning of significant influence of control. And since 2016, their acts came into force, and now it is required to file information about who is ultimately keeping a control over the company. If you're working in other jurisdictions, you may potentially be familiar with the term ultimate beneficial owners, and basically that's what it is. It's the register of beneficial owners, people with significant control. So who are these people? So it's anyone in the company who meets one of or more of the conditions that you can see on the slide here, who owns more than 25% of the company's shares, owns more than 25% of the company's voting rights, or has the right to appoint, remove majority of directors, potentially has the significant influence or control over the company, or has an influence or control over the trust or firm. So even if you have nominee services, nominee directors, shareholders in place, basically you still regard it as the ultimate beneficial owner, and at the end of the day, this information has to be filed to the company house. Previously, in 2016, this new requirement came into force, covering only limited liability companies and limited liability partnerships. And last year, they were talking about implementing similar rules for limited partnerships. And as expected, it is in place today. And since 24th of July 2017, limited partnerships are now also obliged to file same information. If the company is not complying, then it's considered not to be in good standing, and as we understand, the registrar will make certain actions, potentially striking off, dissolving the company from the registrar. If it happens, what can be unpleasant is that if you didn't take your assets from the company, it will be frozen, and you would not be able to do anything unless you restore the company and pay all the penalties. What is actually disclosed? Here on this slide, you can see a real example how information is seen or can be found online. You can see the live snapshot from the company house. You can find any company or any partnership that you want, and if you go to the people's folder, subfolder, you'll see persons with significant control. So what you can see here and what you need to file is name, service address. Usual residential address is also submitted, but as you can see, it's hidden. So, well, luckily, at least it's not officially displayed on the website. Also, you need to provide nationality, date of birth, and nature of the control, and when this person came in control of the company. So this is an obligatory requirement now, as I say, and confirmation statement also includes this information, and all the data is now stored online, and the history is kept basically almost forever, for 20 years thereafter, even if the company is dissolved. So make sure that you are aware of this. Following on with the statutory requirements, you may be already aware that apart from submitting an confirmation statement on an annual basis, there is also a requirement to submit accounting records to the company house. Every company must prepare accounts, and they must file these accounts to the company house. So once, obviously, in a year after the financial year. Default accounting reference date is usually the last day in the month in which its first anniversary falls, and subsequently on an annual basis. You can choose this reference date. There are some restrictions in place. This can be discussed. If you're submitting the first accounting declaration, you should remember that you may not extend the period so that it lasts more than 18 months from the start date of the accounting period. Let's see if I have an example here of the counting the reference date. I don't think I have, but so basically, if the company was incorporated on, let's say, 6th of April 2016, its first accounting reference date would be 30th of April, the end of the month, 2017. And that would be 30th of April for every year thereafter. A company must keep its accounting records and it's at its registered office, and this is a requirement. The records must be opened for inspection if this is asked to. Private companies must keep accounting records for 3 years from the date they were made, and for public companies, it's a 6-year term. As we already learned with you today, directors are responsible to prepare and make sure that accounts are kept as per law requirement. And also, once again, to mention that accounts have to be filed, submitted to the company house. Let's have a look what is usually included in the accounting in the financial information. Accounts usually include profit and loss account, balance sheet, notes to the accounts, and if you have a group of companies, it would be group accounts, so-called consolidated. Also, accounts must be accompanied by director's report and auditor's report, unless the company is exempt, and we will talk about exemption just in a second. Deadlines. When you file in your first accounts, which cover a period of more than 12 months, you must submit accounts to the company house either within 18 or 21 months for public and private companies, or 3 months from the accounting reference dates, whichever is longer. When you file an account not for the first time, the allowed deadlines would be as follows. It's 9 months from the accounting reference date for a private company and slightly shorter period, 6 months for the public company. So here we go. There is an example here. A private company incorporated 1st January 2011 would have an accounting reference date 31st January, and they would have until 1st October 2012, implying the 21 months rule from the date of incorporation to deliver its accounts. If the first accounts cover a period of 12 months or less, the normal times would be allowed to deliver these accounts. And of course, if you fail to deliver accounts, it is an offense, and it's quite an unpleasant, potentially bylaw implications under the criminal offense, and the director may be at risk of facing those penalties and convictions. Here on this slide, you can see 3 categories of the companies. Why it is important to bring your attention to these categories is that depending on where you are with your company, you may be exempt from audit, first of all, which is a pretty expensive thing. The audit. And also, there are some simplified procedures for those companies which are smaller. So you have micro entity company, you have small company, and medium-sized company. You need to qualify for one of their criteria in each category, at least 2 of those 3, to be categorized as per specific type. The 3 criteria are turnovers, balance sheet, and average number of employees that you can see here. So let's say if you have the turnover not more than £632,000, your balance sheet is not more than 316,000, and the average number of employees not more than 10, you are falling under micro entity company. And what that would mean to you, that you would be required to prepare very simple accounting set. It's really simple, even comparing to small company, and there will be an exemption to file a director's report, and also there is an exemption from the audit, which is, as I said, quite a big saving for the company. If your company is considered to be dormant, and by dormant company we mean that there were no significant accounting transactions during the accounting period, and I should bring your attention to the fact that even if you had a single commercial transaction within the year, the company already is not dormant. Dormant transaction means that you've only paid for maintenance of the business, I don't know, to your accountant, maybe to the company house, but you should not receive any transactions from the clients, and the company should not have any commercial activities. If you are falling under criteria of being dormant, also you are exempt from audit, and also you have very simplified ways of submitting your accounts to the company house. Coming on to the end of the life of the company, if you wish to, and here you have a chart with ways how the company can cease its operations. You have 2 major processes. It is striking off or liquidation. Striking off is basically dissolution, and it could be taken in 2 ways: when you voluntarily apply for being dissolved, or when you will be dissolved by force, when you're not complying with the statutory requirements, as we discussed, not submitting confirmation statements or accounting records to the company house, and not responding to the requests to the company house. In that case, they would take reasonable steps to dissolve the company. However, whatever way it is, voluntary or forced, both lead to the potential of restoring the company at the end of the day. Restoration can be administrative or by a court order. We will not go into too many details of the procedure at the moment. Obviously, there is like a certain procedure, and it takes up to 3 to sort of 4 months for both ways. For the striking of dissolution process. Most importantly, for you to understand that both ways quite simple, quite quick, quite cheap, but restoration is available at the end of the day, and all the data is also available upon the dissolution, still live with all the filing history for the 20 years since the date of the dissolution. The second type of closing down your business is liquidation, more complex because it involves their official liquidator. It could be members' voluntary liquidation or creditors' voluntary liquidation. So basically, when the company can't pay its debts, then it would be creditors. When you can settle everything, it would be voluntary. Any data that you want to be removed from the company's house records could only be removed by the court order, I should say. Liquidation is more complex, involves professional advice and qualified liquidator. Now, let's talk about different type of the business, which is the hybrid between partnerships and limited companies. And we have limited liability partnerships. A limited liability partnership is a form of legal business entity with limited liability for the members. Partners are responsible and for their activities, and they share profits as per their agreement, which is called partnership agreement. Two or potentially more members could be associated for carrying business under this organizational structure. Every LLP must have at least two formally appointed designated members at all times. If there are fewer than two designated members, then it means that by default, two of the members in the LLP would be named as designated. What are they, designated members? With the agreement of other members, a member may become a designated member at any time, basically. Designated members have the same rights and duties towards their LLP as other members. However, with designation comes extra responsibility. This responsibility for designated members would be appointing auditors if it is required, signing accounts, delivering all information in accordance with the statutory requirements to the company house, and notifying of any changes, and basically being in charge of the company's activities. In general, acting on behalf of the LLP and presenting the interest of this LLP. Designated members are accountable in law for failing to carry out these legal responsibilities. So you may already see their similarity to their responsibilities of the directors in limited liability companies. As we've briefly discussed before, a lot of points in the Limited Liability Partnership Act were taken from the Companies Act. So these organizations, with regards to administrational side, are very similar in some ways. Registration process is quite simple because it is also could be done electronically. Name restrictions apply in a similar way to the companies that we've discussed, and also you unfortunately can't reserve the name in advance, but as the registration is so simple, quick and easy, it can be done very quickly for you. There is also, similar to limited companies, certain obligations for the information disclosure to third parties if it comes to that point. So LLP can receive a written request to provide certain clarifications regarding their address, their place of the address for the place of inspection, where LLP should keep their registers similar to sale address of the limited liability company. Usually each company or each LLP is given 5 working days to provide information upon the receipt of such request. LLP must keep also their records available for inspection. Again, we can see the similarity here. You should keep registers of members, registers of residential address, and accounting records. Maintenance. Confirmation statement, same requirement, and same 14-day rule. Basically, once in a year, you should submit a confirmation statement 14 days after the made-up date, meaning the last confirmation statement date made. Information included in this statement would be usually confirmation of name, registered number, obviously the names of the members and their addresses, and if there is a single alternative inspection address location, you should also be disclosing and confirming that. Accounting requirements also exist. You also need to supply this information to the company house. So you should prepare and file it during the financial year. Financial years are determined by reference to an accountant reference period, similar to those examples that we've seen before. And for all LLPs, basically, legislation sets the first accounting reference date as the last day in the month in which the LLP first anniversary falls. For example, LLP Incorporated 1st October 2016 will have its first accounting reference date 31st October 2017, and 31st October will be the reference date thereafter. You can change accounting reference date. Some restrictions apply, but again, this can be discussed with us if you wish to. Accounting records similarly should contain same information as a profit and loss, balance sheet, notes, group accounts, attention auditor's report if there is no exemption. They should also be filed to Company's House and Her Majesty's Revenues and Commissions, and they should be kept for 3 years from the date when they were made. So here you can see in more details the deadlines for such submissions. If you're submitting first accounts, again, similar rules to private companies limited by shares. So first accounts can be submitted within either 21 months of the date of incorporation or 3 months from the accounting reference date, whichever is longer. The deadline for the delivery is calculated to the exact day. Here you can see again an example. If you incorporated 1st January 16, your accounting reference date end of that January, and that means applying 21 months rule that your deadline would be 1st October 2017. I should actually mention that when you go to Company's House online website, you can easily find information advising you the deadlines of submission for accounts and confirmation statements. So the system, the Company House system, calculates these preset dates for you. So don't worry about taking notes of this, because you can easily check this at any given date if you wish to. So, as we've seen, for some limited liability partnerships, you may need to file audit reports. So it's also important to understand where you stand with regards to your business categorization. You can be regarded as small or medium-sized. Same 3 criteria where you should fall under at least 2 of the following conditions. Again, it's turnovers, balance sheet, and number of employees. And if you are the small LLP, then you would benefit from the audit exemption. Also, LLP can be regarded as dormant. Same rule applies. There should be no commercial transaction within the year. And if you if you're falling within that requirement, you would be exempt from audit, and a simplified process of submission of your accounts would be applicable. Regarding ceasing the business activities, similar ways again. So I won't go into too many details. Basically, again, you can go with either liquidation or strike off, which could be either voluntary or forced, and liquidation could be again either by their creditors or voluntary. Same option for dissolution at the end of the day, could be restoration, and data would be also available for quite a long time online. Now, moving on to another partnership type, which is a limited partnership, also pretty popular, I would say, within international clients. Historically, limited partnerships were used by accountant firms, and it is still in place, I would say. It is governed by the different legislative act, which is Limited Partnership Act 1907, and it is different slightly from LLPs and LTDs that we have considered. So to register, you must deliver an application. Sorry for that. Please excuse me. I can see that my slides are not clicking for some reason. But okay, I'll go through this. Not sure what's going on. Interesting. Okay, I have a lot of slides for the same material. Right. Anyway, I'll talk you through the rest of the presentation anyway. So registration process is pretty no, not pretty standard. It is standard, but it's different because it could be done only on paper. Also, you should choose the location for your limited partnership. And as I've mentioned in the beginning of presentation, if you remember, when LTDs are usually located in England, limited partnerships are usually located in Scotland. And why is that? Just give me a second. I want to try to scroll down. Strangely, the presentation is not really working. Right. Just give me a second and I will try to pull a different type of presentation. Sorry for that. Okay, here we go, live again. Right, the presentation seems to be sorted. So going back to what we've been discussing, limited partnership, registration procedure only on paper, restrictions for names also apply, and name reservations are not applicable. So as I said, pretty standard that limited partnerships are registered in Scotland specifically. So why is that? Scottish limited partnerships can be distinguished from English as they benefit from having a legal personality separate from their partners, which is pretty uncommon for partnerships in general, as we initially saw that unincorporated business is usually partnerships. Scottish LPs can raise legal actions, be sued in its own name and own property in its own name. So this is the distinctive characteristic that brings attention to specifically Scottish limited partnerships. As an entity with separate legal personality, Scottish LP is likely to be treated in other jurisdictions as a foreign entity distinct from its partners, and such flexibility of treatment basically brings the benefit to this specific location of partnerships. Talking about accounting regulations, again, this is now different from what we've seen with LLPs and LTDs, because although there is an obligation to keep the accounting records, but there is no requirement to file those accounting records to the company house unless these limited partnerships fall under certain criteria, and if it's qualified partnership, then it would be still required to submit accounts. A qualifying partnership basically is a partnership formed under the law of any part of the United Kingdom if each of the members is the company in the UK, basically. And if you are falling under criteria of qualifying partnership, then you would require to submit accounts to the company house. Usually, for international business that come to work to the UK as a limited partnership, partners are non-resident companies, meaning that this qualifying partnership is not applicable and accounts are not being submitted. However, I should mention that although the accounts are not required to be submitted to Company House, you should not forget about HMRC, and there is still requirement in place to submit your tax return to the tax authority department. We are coming to the second part of our presentation, which is pretty small because it's just a very quick snapshot for you to understand what is the major difference between tax responsibilities of companies and partnerships. So let's talk about tax responsibilities for limited companies. The major tax that company should consider is the company corporation tax on taxable profits. So every financial year, the company must put together their accounts. Obviously, as we've discussed, you need to send these accounts to the company house and also send these accounts with company tax return to HMRC. So just to bring to your attention, always remember there are two reporting authority of governmental bodies, which is Company House and Tax Department, which is HMRC. If you are working within the UK, then you should consider about registering for VAT. If you are not working within the UK, it's almost impossible, to be honest with you, to get this VAT registration number. Corporation tax, it should be paid. And here on the slide, you can see the deadlines for filing a tax return and paying actually the corporation tax. You should file the tax return 12 months after the company's financial year end, and the payment should be made 9 months and 1 day after your company's financial year end. So keep this in mind, please. Regarding the actual percentages of the tax, you can see here on the slide a nice deteriorating chart of rates, which is good. Once again, UK is always considering to be the leading jurisdiction in bringing international business in. So you can see that they're making attempts to decrease the corporate tax and in such a way attract international business to come and work in the UK. Important changes that I would like to mention were announced in 2016 by the UK Chancellor, Mr. Osborne, and he then advised that he wants to work on reduction of the corporate tax rate, and he promised to reduce the tax rate to 19% from 20% that was in existence, with an effect taking place on the 1st of April 2017. And by April 2020, he promised to reduce the tax rate to 17%, which is, I believe, brilliant news. So now, as you can see, highlights in red, this year already the tax was reduced to 19%. Before we move on, I just want to bring to your attention to the fact that if your company is considered to be dormant, you probably, potentially, like almost 100%, don't have to pay any tax because the company was not trading, it was not in operation. But you should still remember that you need to submit tax return to HMRC, even if it's a nil tax return. So now we're here talking about tax responsibility for limited liability and limited partnerships. The key difference is that tax obligation is on the partner, not on the organization itself, as we saw with the LTDs, but actually on the partner. So before you can estimate what's going to be your tax, you need to understand where the partner is the tax resident. And depending on his, hers tax residency, then you should understand what your tax would be. Obviously, if you are the tax resident in the UK, then you would go through the route of submitting self-assessment to HMRC, and you would look into the personal tax rates in the UK. If you are acting as a partner, as a non-domiciled foreign company, then you should look where the company acting as a partner is a tax resident, etc. Coming to the end of our presentation today, we will summarize how the companies are usually used in the UK. Pretty much in all the ways, to be honest with you, because different companies choose different reasons to be registered in the UK. It's prestigious location. It's just being in that jurisdiction which is transparent, offers simplicity, offers support, and there are different factors basically to it. That's why we can see all types of companies registered here, like holding, trading, finance management companies, etc. UK has a large network of double tax treaties, which you should remember about. However, I should also mention that in order to apply this double tax treaty, the company should be treated as a tax resident in the UK, and this is one of the key criteria. Obviously, the matter of how the company is considered and why and when is a tax resident is another matter, but just to give you sort of hints, it's a management and control principle that needs to be taken in the consideration. On this slide, I've just shown you one of the most common type of the structuring, which was existing for, I don't know, in my practice, like at least 50% of companies internationally. It's so-called agency structure, when the UK company acts as an agent. Basically, UK company pays corporate tax on commissions received from income. In that case, UK company acts as the front, issues all invoices, and this brings the satisfaction and reassurance to the counterparties because they are dealing with their UK jurisdiction in itself. However, because the UK is just an agent, it only receives agency commission, which is like 5 to 6% usually from the turnovers. And in that case, obviously, you understand that major part through their agent goes to the principal, which is usually an offshore company, which could be registered anywhere in the world. And here on the slide is just an examples of BVI, Seychelles, etc. But that is really diverse. And company pays tax, corporation tax, obviously, only for the profit, which is that marginal commission of 5 to 6%, less all expenses, obviously. Regarding limited partnerships, limited liability partnerships, once again, the usual sort of arrangement would be using partners which are not basically the residents for the UK. I can see the question popping up, what time we're finishing. We're finishing now. Don't worry, that's the last actually slide here. I won't hold you much longer. Yeah, so this is basically it for today. Usually there is much more to know about taxation and different implementations because the world is changing. It's becoming more complex. There is an automatic exchange of information everywhere. Bank secrecy is changing. Banks' requirements are changing. Such jurisdictions as the pure so-called tax havens are not accepted anymore by their major banks pretty much internationally. So there is a lot of points that you need to take into consideration, but don't worry, that's why we're here. And if you have questions, we're happy to provide a consultancy service for you, plan your structure and assist with your business. I will be summarizing the presentation today, and just for those who are maybe not familiar with Eltoma Corporate Services, we are located in various countries. We have office in Singapore, Hong Kong. I'm located in the UK. We have office in Cyprus, Russia, and Ukraine. Our specialists are lawyers and professional accountants. So we are providing registration in various jurisdictions, and it is more important now to take into account legal services and tax planning services before you incorporate the structure. And that's what I would urge you to do before setting up your business. Get their professional advice first. Of course, it's up to you, and but just the world is changing. That's all I want to say. However, also summarizing what we're doing here, I want to mention that we've launched a new property project because we found out with our clients that immigration is becoming very popular, and here we go. We have an offer for you to obtain the passports through Cyprus Investments. So I've been in Cyprus living for 5 years more than. It's an amazing place. It's brilliant, honestly. So have a look at this sunny weather here. For those who are in the UK now and experiencing rains, yeah, that's very very different, and it's almost summer all year round. So if you're interested in relocating service, please do contact me, and we can talk about just sort of investment project, or if you want an investment for obtaining passport. Thank you very much. These are our contacts here. Please do feel free to send us a message to info@eltomaglobal.com. My name is Dina. I hope you've enjoyed the presentation. If you want to purchase this record today, this is available for the purchase. I think it's like 20 or 35 euros, if I'm not mistaken. But get in touch with us. We can talk about your case, and we can discuss what you are interested in. And me or my assistants would definitely help you to make the right choice in the right jurisdiction. Thank you very much. I hope you enjoyed, and have a good day today. Thank you.